but we don't want to miss the opportunity. A few announcements. If you have not already signed a petition to restore the voting rights for former felons, would you please stop? And there's packets as you leave tonight. And if you'll take 10 of those to your family and friends and then return them to us, we'll process them for you. We need to do this to get it on the ballot for the general election. Mary Jane is out there and she can answer all your questions. In terms of upcoming programs, October 3 is our legislative preview. It's in this building at 6:30, and that's with the county delegation about the bills that the county will be supporting in the legislature. On October 17, part of our White Court Matters series that we did last year, and again was very popular this year, and it's on reproductive rights. It's an interactive, as if you were the judge in making decisions. And it's on reproductive rights. It's at the Delray Beach Public Library. We do need to know a reservation if you're intending to come to that, and you can do it online. It is a limited attendance. October 29, hold on to your wallets, it's our fundraiser. It's a Sunday afternoon with a luncheon at 1 o'clock at the Atlantis Country Club. It's truly social, not always a typical league meeting. The theme is all that jazz. We will have those beautiful gift baskets. They're really luxurious gift baskets that you can have raffle tickets for. And we will have some wonderful entertainment. As you know, I teach piano. I'm happy to tell you that we're having Copeland Davis, jazz pianist, is our entertainment for the day. So it's wonderful to bring guests and family to. It will be an enjoyable day. We are going to be live streaming today, as we do with all our cool and hot topics. So please keep the chatter down because it's picked up. Make sure your cell phones are on mute, or even better, off. At our monthly Hot Topic luncheon, we recognized what we said was a hero of the month. We have the other half of the duo with us today. At that meeting, we were talking about court decisions and how they impact our daily lives. There are consequences to almost all of our decisions. And the League is calling attention to the decision factor that has gotten a lot of press lately. It's the role of conscience in our decisions. We're all shaken by the recent demonstrations in Virginia, and it's frightening to see such discrimination and hatred on display in our country. When these situations arise, each of us must decide how to act. I'm proud to have as my guest today a woman who is a role model to all of us. I would ask if Laura could stand up.
That's why I'm here to sit her in front.
Laurel Baker is the Executive Director of the Palm Beach Chamber of Commerce. When organizations were considering changing their venue, when an owner did not condemn the neo-Nazi demonstrators, Ms. Baker was asked to make a public statement. She replied, each organization must examine their conscience and make a decision. She didn't tell them what to do. She simply reminded them of the consideration process each of us must use every day. When criticized by some, I'm happy to report that her employer, the Palm Beach Chamber of Commerce, which we honored at our luncheon, said that she was expressing her personal opinion and refused to put her job in jeopardy. Words do matter in our society. There are consequences to the words we choose to use. I admire those that give thought to their words and actions. I also respect organizations that understand that using your conscience is the right thing to do. Nations that rule by conscience do the right thing. They don't let greed, ignorance, and intimidation rule their country. So I'd like you to join me in applauding Laurel Baker.
Only that my mother would be rolling over in her grave because she always said, just keep your mouth shut. Don't say anything. But I obviously never listened to my mother, and I truly hope that all organizations, including League of Women Voters, you have to look at your mission statement, and you have to live by it. And if you compromise it you may as well not have an organization. So I thank you very much for acknowledging my big mouth. I don't know whether my mother would be any prouder, but she's probably laughing now. So thank you very much. I appreciate it. Thank you.
We'll be mailing both these women a gift membership to the League. For those of you who have not been at our recent meetings, I'm going to do a bit of boasting. You know, we've had a lot of growth in the Palm Beach County League. We are now the third largest league in the United States.
Yeah.
We're still at 700 members, which is really great. We have a fabulous speaker. I'm lucky enough that I lucked out and signed up for some of his courses and have taken them ever since I took the first one. He's an entertainer, he's a great speaker, he does enormous research. And he's going to be, when we booked him a couple of months ago, it was timely. Well, he's got a whole menu of things to talk about now, new subjects since we originally booked him. I know you're going to enjoy Irving Leibowitz.
Thank you for having me. It's a delight to be here. I think this organization is marvelous. As President Obama said in his most eloquent days, you do good stuff. And you really do. And I'm delighted to have the privilege of being here with you. One thing I did find that was disconcerting, when I first was asked to speak here tonight, I could not quite understand why we were going to be having a lecture from 6 to 7:30, give or take. But I thought it had something to do with hall function or other issues, so I thought it was all right. But then when I arrived here tonight, I was truly annoyed to find out that in addition to the stalwart group of people who are in person, there are about 1,000 of you who are eating pizza and drinking margaritas. Right? So to those of you who are here, take out your candy wrappers, your gum wrappers, and do anything you want, because I think you deserve it. As back to the topic of tonight, the topics of tonight, I used the meal motif, kind of clumsy, but it gets your attention, because indeed I thought we weren't going to be having dinner here at all, or an opportunity. And we agreed on a number of topics that were of significant interest to all of you. Well, things change. I'm going to try and address as many of the topics as I can, not in the kind of great vertical depth that I'm used to in a law school environment or in a more formal teaching environment, but I will try and cover as many things as I can, and obviously I think I have decided to add a few additional items that I think are rather timely, that you might find useful as we discuss. So, with that brief introduction, let me start to take you through some topics that I have of interest. Now, what I'd like to do, those of you who have taken my courses with me at FAU know that I do not have a Q&A at the end of a lecture, particularly because I address multiple topics, you see, and I don't want to lose the stream of consciousness that we all have. And I usually try and address questions or receive comments as I'm in the midst of concluding each topic. I'm prepared to do that again today with one caveat. I have so much to talk about and so much to present to you for your absorption that I might not be able to take the usual amount of lengthy questions or lengthy dialogue that I do in my classroom or that I would in other lecture environments. But I do invite, please, a hand raised, and I'll endeavor to address you, and perhaps we can all learn from you. I find that for the most part, the students are smarter than the teacher. The only advantage I have is the clicker. And I intend to take advantage of that too. So, may we get started?
Oh, yes.
Okay. This is going to be an interesting ride. What have we talking about? Of course, we're talking about the most famous old bird of them all, gerrymandering. That was one of the topics that you asked to discuss tonight, and I'll be glad to do it. And just so you'll know that I'm truly an expert in this subject, you see Lynn, Massachusetts? That's where I was born and brought up, so it had to have rubbed off. This was the one of the local little counties in Lynn that Governor Gary, back in 1800 plus, decided he would like to.
Oh, here, the letter. You bet.
I promise I won't do that again.
Anywhere you want.
Governor Gary, and it was not Jerry, it was Gary, he decided that there was a wonderful idea he had, using the Constitution as a basis, because the Constitution said congressional legislative districts in each state can be based upon the whim and caprice of the state legislators. The boys in the back room. There's no other way to express it. The kingmakers. So he got together with the kingmakers in the Commonwealth of Massachusetts, and they decided, in order to perpetuate a continuum of the reign of their particular party, that they would so reconstruct and twist and turn and shape the various congressional districts to assure that the population would vote the way they want them to vote. Pretty simple. A pretty interesting idea. And they snagged it right from the Constitution. Now, the Constitution also says that Congress can change this anytime it wishes, but until Congress changes it, it remains at the whim and caprice of the boys in the back room in each state. Will it come as a shock to any of you to realize that Congress has never changed it? Has it left it alone? Because those who are in power wish to remain in power. There's nothing wrong with that once you understand it. So, let's talk about the constitutional underpinnings of all this. Article 1, Section 2 starts off by saying every 10 years there'll be a census. So this was the original Constitution. See? So we've had this every 10 years ever since. Now, we're not going to talk about the fact that then Negro were considered as 3/5 of a person under the Constitution. That's one of these things we sweep under the constitutional rug a little bit. But it is there, right in the Constitution, in Article 1. Now, Article 1, Section 4 is the portion that says the state legislators will decide in the absence of congressional intrusion, which, as I said earlier, has never happened. So, this beast turned out to be not gerrymandering, but gerrymandering. And the term gerrymander, to manipulate, which I think every husband appreciates happens to him by every wife. We get directed and we receive suggestions and we understand exactly what we're supposed to do and how we're supposed to do it with some certitude. It's not quite called gerrymandering, it's called loviness. Gerrymandering is what we've been living with. And believe it or not, this case that I have on the board now, Whitford versus Gill, it's docket number 16-1161, the United States Supreme Court, is going to be heard on the 3rd of October. Pardon?
They're just starting.
Opening day.
Yeah.
Opening day for the Red Sox, opening day for gerrymandering, which is why I felt impelled to bring it to your attention right out of the box. Now, this case is the latest of a series of cases over the last decade or so that have caused some significant changes in the way gerrymandering is viewed and the flexibility afforded to the state party bosses. It is either good news or terrible news, depending on your predilection, that the state bosses have lost considerable amounts of power. And by the way, this league, in no small measure, takes the blame or the credit for doing absolutely spectacular work in Florida and in other jurisdictions to change the prejudice that has existed since 1790 in this area. The issues, of course, are the First Amendment, 14th Amendment due process, and what is being looked at is whether or not gerrymandering has resulted in racial bias and partisan gerrymandering. Those are the two operative terms that the Supreme Court is going to be concerning itself with on October 3rd. And by the way, you can watch the Supreme Court, or get an audio, and listen to the Supreme Court argument, which, by the way, is always magnificent. If you want to talk about intellectual discourse, and you want to talk about reasoning, listen to the Supreme Court argument. All you have to do is just look for SCOTUS.gov, S-C-O-T-U-S, Supreme Court of the United States, SCOTUS.gov. And when you look at SCOTUS.gov, it will tell you exactly, in a subset, the oral arguments that have been transcribed and are ready to be the subject of your listening. If you do it once, and I tell this to every single one of my classes, if I can get you to listen once, I will have you hooked. As though I was selling narcotics. The first one is for free. Listen and you will love it. You will have great faith in the institution. Those are the issues that are going to be generally discussed. Now, by way of a little bit of history, evolution, or, depending upon your point of view, devolution. I don't want to get in the way of your thought process. You believe whatever you want to believe. The purpose of this lecture is simply to prevent facts as they are undisputed, legal precedent as it has developed, the issues that are now before the courts, and I leave the yelling and screaming to those of you who are inclined to do so. In 1946, in the modern era, the Supreme Court of the United States, in a case called Calgrove versus Green, 328 United States reports. And by the way, all you have to do is just Google what you see on the board here. And everything you wanted to know but were afraid to ask, you'll find. It's all there. It said, in explicit terms, the Constitution says that establishment of congressional districts is left to the state legislatures, their configurations, unless Congress intervenes, and of course, as we've said now, Congress has never intervened. And the Supreme Court just repeated the words of the Constitution and left it alone. In 1986, a very strict test was developed for the very first time. This was the first modern inroad into unlimited and unconstrained gerrymandering. First time in which the Supreme Court of the United States in Davis said, if you can show that there's a clear and unambiguous intent to discriminate, we'll think about it as a First and 14th Amendment violation. They were unsuccessful in that case, and the test in any event was viewed as significantly stringent and harsh, so as to create a barrier that was very difficult to overcome on a factual basis. And by the way, finding out the facts wasn't so easy either in this area. In 2015, sea change. And the League of Women Voters in Arizona had a lot to do with this. Some of you may not know that. We had a circumstance in which the Arizona legislature was in great shape. They loved it just the way it was. Back rooms, cigars, everything you think of. They were choosing it. Their party was going to be in office forever, because you would take other folks who were coming in to Arizona, fleeing the New England winters and the winters in the Midwest, and you would pack them into little places, and you would stuff them here and move them there and twist the legislative districts so that they would not have disproportionate voting power. So you'd stick them all in a place. The term ghetto was used more than once, by the way, by organizations, and not subscribing to that point of view. There was a referendum for the voters of Arizona in which the Arizona Independent Commission, composed in no small measures by members of this very organization, said, why don't we have a referendum so that all the voters of Arizona can decide whether or not they want to expand the ability and take the power away from the state legislature. Oh my goodness, what a novel thought that was. And they did it. And the referendum was approved, and it set up an independent commission with one voting member right on the part of the legislature. The legislature didn't like it very much because it deprived them of their historical power. That's why the case is Arizona legislature versus the independent commission. And guess who won for the first time? The independent commission. Now, there are constraints. There are important constitutional limitations on how the commission was able to get around the constitutional prohibition. And I'm sorry I do not have the time to get into that kind of depth. There'll be some other times when perhaps we will. In my classes, I have a little more relaxed time to do this. But you've run a very tough ship here with me because you insist that I talk about a lot of topics. So I hope this will whet your appetite, if not satisfy your intellectual curiosity. That was the first big breakthrough. And that was only in 2015. We're not talking about centuries ago. 2016, Cooper versus Harris, the Supreme Court more pointedly said, you're not going to pack blacks into ghettos. That's just one line, and there's a lot more in that case. But you can see a sea change beginning. You can see a trend beginning in the last few years of this modern era. Now, even though you may have presuppositions as to the way various members of the Supreme Court will be inclined to vote, I urge you, take a step back for yourselves and listen to the argument, and listen to whether or not the justices, when they are probing counsel at the dais, may be learning themselves as to the direction to go in order to provide due process and Amendment 1 protections. October 3rd is going to be a big day for gerrymandering, a very big day. We'll wait to find out what happens. That's all I'm going to do. I can't do any more gerrymandering today.
Oh, well, before you move on from that topic, can I ask a question?
Indeed.
So my question is, first that you said Congress has never intervened.
Mm-hmm.
Now, the constitutional crisis is actually that Congress no longer represents the distribution of the public, of citizens of America. And so, but...
Am I supposed to agree with that?
Well, whether you do or not, it's my contention.
It's your point of view.
It's my point of view.
So
Absolutely.
you believe that Congress does not?
Well, you said Congress has never intervened, but that doesn't include that every 10 years after the census, Congress added members of the U.S. House, thereby changing the number of districts in each of the states.
But it's not. Did you want to hear his question or his comment? The addition, the Constitution says there shall be one district for every 30,000 people, right? 30,000.
Right.
It doesn't say citizens, by the way, and it doesn't say voting members of the United States. It says people. So when you hear one person, one vote, it's kind of a misnomer, but it means that you count all the folks. And everybody is entitled, who's lawfully here, to be, who's in the census, is entitled to be part of the group. With that in mind, please continue.
Right, that is exactly my point. We now have districts of more than 1 million people on the large side and about 500,000 people on the small side that are wildly unequal. And that is causing massive distortions.
But is that because of congressional intervention or because
Yes.
of population swings?
Congressional non-intervention, since the Permanent Apportionment Act of 1929 that said, well, you're going to have 435 members of the House, and they stopped adding members of the House after that. So instead of having 30,000 people in the district, it ballooned to all the way up to more than 1 million.
Do we concur that at least Congress has not intervened?
Well, since the Permanent Apportionment Act of 1929.
I just
They have
have to
before
intervene.
that.
Actually, Palm Beach County Chamber has brought this to the national attention of the league in Florida. It is now being adopted. We were the proponents of this. We are now supporting the national popular vote. And the chair is right here, Nancy Cohen, the expert on this committee, and we would love to have you join that committee. This is one of our priorities in the Florida legislature.
Now, you can handle me with ease. Do you dare?
I have tried. I was just trying to get my point in that we need to add members to the U.S. House. Not what she was saying.
The next topic that and I don't mean to push it aside because it's valuable. It's just a matter of time constraints that limit it. I'm glad you raised the issue. They've learned from you. You've learned from them. I've learned from both of you. Next topic, using again this rather primitive dining motif. The executive order travel ban. Well, up until just a day or so ago, this was really a hot meal. This was hot stuff. Because on October 10th, there was going to be an argument before the Supreme Court of the United States. The issues were the First Amendment, freedom of religion, and whether or not the people who were trying to come into the country had standing to speak for themselves, either in representative capacity or directly. By way of historical perspective, again, in the modern era, we have a very famous case called Zivotofsky. Those who take my class are sick of hearing me mention the name Zivotofsky because every time I do it, I have this irresistible feeling that I have to emote. So I call it Zivotofsky, as though I were an opera tenor, you see. U.S. Jewish baby born in Jerusalem. Parents wanted to puff and say, our son was born in Jerusalem, the capital of Israel. They're entitled to that. Except the State Department said, oh, no, things are a little bit too tricky. We don't want to say Jerusalem is the capital of Israel just yet. Give us a little bit of time, because there are some other folks who don't think that Jerusalem should be the capital of the Jews. It should be the capital of other groups, and maybe not even shared. So the State Department said, why don't you just leave that alone? The question was, the President of the United States, or the executive branch, remember we have three branches of government in conflict all the time. Article 1, Article 2, and Article 3. Article 1, Congress, Article 2, the executive branch, and Article 3, the judiciary. They're made to fight. And by the way, has anyone heard of Baron de Montesquieu? Good friend of mine. He was born in 1573. He was a French philosopher who first emoted in a very famous paper that in order to have democracy which had a potential for success, you had to have conflict because you couldn't trust the democratic society in a unicameral circumstance. You had to have conflict to keep everybody honest. And by the way, James Madison, of course, who was the father of our Constitution, not the Declaration of Independence, the Constitution, bought into that and was the guiding light in having everyone remember those words. And that's why we have what we have. So Zivotofsky said, the Supreme Court said, although the ultimate authority to determine constitutionality remains with the judicial branch, because foreign affairs and military affairs are of such significance to the executive branch, and the executive branch knows so much more about these things than do we, said the justices, we defer to the executive branch unless there is a strong constitutional violation that has occurred. This brings us quite current now to the President of the United States, who issued an executive order some months ago. And on 9/25, September 25, in Trump versus Hawaii, the Supreme Court of the United States canceled the hearing. But do you know why? It canceled it because the travel ban expired last Sunday. Just expired. So the matter was moot. There was no controversy to be the subject of legal argument and legal determination, because Article 3, Section 2 of our Constitution mandates that there be an actual controversy before the judges at any level can hear a case. At every level. So, what we have right now in its place is something new. Please keep your eye on something called the proclamation. The proclamation issued also by sheer coincidence. The proclamation issued on Sunday night, the very same day that the executive order and its progeny were on the cusp of being heard by the Supreme Court of the United States. Now, the difference between an executive order and a proclamation, let me just do this in very quick fashion. An executive order, the President of the United States is the CEO of the federal government under the Constitution. So he issues, or she issues, an executive order that simply says, I'm looking at a law, here's how I interpret it, I'm the boss. And as long as you're working for me, and I'm the boss, you'll do it my way. That's an executive order. It's to all members of the federal executive branches who work for the president and deal with all of us every single day. A proclamation is to everybody. A proclamation issues to everybody who might be the subject of a particular law and says, here's how I read the Immigration and Naturalization Act, says the President of the United States, and I'm issuing a proclamation in order to take the place of my former executive orders, which didn't make out so well. And I'm going to have a new travel ban with 8 countries in trouble. I'm taking some away, I'm adding some new ones, and instead of just a 90-day restriction, which is what we had before, there are a couple of them that are indefinite. The new proclamation does not have symmetry. It is nicer to some of the countries that we don't like, and it's harsher to other countries you don't like. The question is, will it ultimately turn out to be a continuing ban against any faith? And will it be the 4 corners of the proclamation, or will it be what the President and his acolytes have been saying in the meantime that expresses their view as to the intention of what is now the new proclamation? We are now on the ground floor of a whole new raft of litigation, taking the place of everything you've read and heard about from the executive orders, but now we call it the P word, the proclamation word. It's going to be same old, except the executive branch is a lot smarter now. There will be much fewer mistakes made by way of language. There will be very few, I suspect, self-inflicted wounds, as there have been before this time. We have to wait and see. Okay. May I go on? Yes, ma'am.
I'm not sure I understand.
Me either.
But I'm in good company.
Yes, ma'am.
The significance of this Zivotofsky case, how it affects the travel ban. Like, unless what you're saying, if this is what you're saying, that that the Supreme Court is saying we defer to the executive with all.
Not totally. What Zivotofsky said, while we maintain the established legal postulate that we, the judicial branch, Article 3 of the Constitution, have the ultimate right to determine whether or not any executive order of the executive branch is constitutional, short of there being a substantial violation of constitutional rights of those entitled to enjoy those constitutional rights, we will defer to the executive branch. And Zivotofsky is the last case of substance to restate the principle. Okay? Thank you. Okay. You getting tired of this lunchtime metaphor? When I first did it, it really sounded a lot better than it does now. Impeachment. Where are we going with this? Is it sizzle or is it steak?
Steak.
Well, that's the reason for the next 5 to 10 minutes. First of all, historically, please understand, this is not a big seller on the menu. This doesn't happen that often. We only have 18 cases, all total, of high government officials who've been the subject of impeachment. And let me give you a quick quiz. Who was the last target of a successful impeachment proceeding in the United States of America? What high federal government official? Anybody know?
Roy Moore of
Pardon me?
Roy Moore of Judge Moore of Alabama.
No.
President Clinton.
Well, now, come on, you know he's an Alabama Supreme Court judge. No, you're just espousing a point of view. There he is. Now, if you were in my class now and it was time for my Halloween candy, you would get 2 Hershey bars from my 2011 vintage stuff.
say? What did she say?
He's right there. Alcide Hastings.
Yeah.
He was a federal judge, and he was disbarred. And by the way, he also represents West Palm Beach today. So by coincidence, it just happens to be pretty close to home. All right? He was the last one. Now look, only 3 presidents ever implicated in this business, but none ever removed. I don't think I need to put the names down except for the first guy. Andrew Johnson, Richard Nixon, and William Clinton. Now, Article 2, Section 4 of the Constitution speaks to impeachment. Treason, bribery, and other high crimes and misdemeanors. Well, what is a high crime as opposed to a low crime? I mean, a low crime might be trespass or a speeding ticket. Right? Misdemeanors usually means crimes that are not punishable by imprisonment for more than a year. So what are we talking about? Is this the only help we have in deciding what is a high crime and misdemeanor upon which to predicate an impeachment action? As you can see, the Constitution didn't give us a heck of a lot of assistance in this regard. Now, treason, please separate treason. I've heard the word treason bandied about in this context. Put treason on the back burner. Treason is really hard. In Article 3, Section 3, Clause 1, you really have to climb a mountain to convict someone of treason. And there has to be corroborating evidence by at least 2 witnesses. It's a hard sell. Without getting into detail, because there's no time again tonight, please leave treason out of your equation for the moment. Those of you who are hoping for treason, as they say in New Jersey, forget about it. Right? Forget about it. Now, there's James Madison, one of my heroes. In Federalist Papers 56, those of you who do not know what the Federalist Papers are, outside of letters written between John Adams and Abigail that have been chronicled, and several other exchanges of letters involving George Washington, we have no record of what the Founding Fathers were thinking, what they intended when they drafted and penned the final language. Except there are a series of 80 monographs put together by John Jay, Alexander Hamilton, and James Madison, which in their aggregate are called the Federalist Papers. And they were contemporaneously prepared statements as to where the colonial legislature was, the convention was, at all times as they were going through the Constitution and preparing it. So it's a marvelous resource and one that lawyers and judges in their decision-making all rely upon. Now, James Madison first coined this phrase in the Federalist Papers number 56, referring to 14th century English Parliament. And here's what the Founding Fathers listened to and what we think influenced the Founding Fathers. Those offenses which proceed from the misconduct of public men, abusing or violating their public trust, and of a nature which may with particular propriety be denominated as political, as they relate chiefly to injuries to the society itself. Now, if you can get your arms around that kind of amorphous phrasing, you understand that they were thinking of matters of great significance that impacted upon society as a whole, as our nation as a whole. Not blue dresses. It's a very hard sell to impeach, and it should be. The House initiates, requires a majority vote to impeach. Now, all impeachment is, at the House of Representatives, is the functional equivalent of a grand jury proceeding. Anybody here ever served in a grand jury? Yeah, I'm sure some of you have. Find probable cause. Right? It is not finding of guilt or innocence, just a likelihood that this really could have happened, which is the basis upon which you then subject a defendant to a public criminal trial. It's supposed to be a safeguard. It hasn't always turned out that way, but that is the way it was intended by our founding fathers. The Senate is where the trial occurs, with the Chief Justice of the Supreme Court of the United States presiding, and this mandates a 2/3 vote for removal. Nothing else. 2/3 vote for removal. This is not easy. So, before you go rushing down that track, consider the barriers and consider the likelihood of it being successful. Also, a subject that I simply do not have time to talk about tonight. I was planning on it until two other things came up that became more important to me. The 25th Amendment in 1967. Now this 25th Amendment simply says, if a president becomes disabled, the amendment doesn't say physically disabled. The amendment doesn't say emotionally disabled. It simply says disabled. There are those who now are plotting, rightly or wrongly, to take advantage of the 25th Amendment as an alternative to an impeachment, to simply take away the presidency, initially on a temporary basis, and the basis appears to be, according to opinions that have been written, although the 25th Amendment is unfortunately and strangely silent to the point, it needs the concurrence of the Vice President of the United States and a majority of the members of the Cabinet. Now, that's not authoritative. That's anecdotal, because those are the opinions of the Department of Justice, legal department, that issued after President Reagan was shot. That's the only clue we have. There are no judicial decisions. So the 25th, and then, by the way, it's also an important issue as to what happens if the president is disabled voluntarily or involuntarily, and then wants to come back. We have no idea what happens next. The Constitution is silent to this issue. So if you want to talk about the fact that inaptitude of language sometimes exists at the highest levels, what makes us a living as lawyers? Always arguments to be made. Always arguments to be made. Keep your eye on the 25th Amendment if you have a moment. It may become very important soon if this matter becomes a subject of judicial proceedings. Then I'll be talking to my classes about it, and we'll be exploring it more in depth. Yes, ma'am.
What about, no comment, what about morally vacuous? I mean, really? Would that be, you know?
I've been accused of being morally vacuous, and I think I'm a substantial citizen, you
It's
know.
not that funny, college.
The 25th Amendment just uses the word disabled.
Okay.
Beyond that is a matter of personal persuasion, where I fear to tread. Okay. This is one of the subjects I felt impelled to bring to the fore. How to say grace. I'm actually embarrassed about putting this stuff up. So bear with me as I go through the rest of these topics, because I'm stuck with that. I can't change them now. How to say grace to honor our American flag and anthem before savoring our game. I actually thought it was pretty cute when I did it. All right. 8-year-olds. This is Friday night, past Friday night, in Illinois. 8-year-olds are learning to take the knee. Right or wrong, good or bad. Now, I suspect that the opinions in this room will either be hard left, hard right, hard yay, hard nay. There will be very little indifference. So all of you are entitled to your opinions, regardless of your persuasion. I took the liberty of putting one of the statements of the president on the board. I chose to take one that avoided vulgarity, because I really didn't want to go down that line.
That's rare.
Yeah, discreet is my name.
Oh, okay.
Don't play the food game with me here.
Okay.
If a player wants the privilege of making millions of dollars, he shouldn't be disrespecting it. We all understand what the president's view is, and we understand what the owner's view is, and the question is, when you saw the owner's holding on to their players. Did you get the feeling there was some discomfort on the part of the owners? But hey, they were playing ball. All right. In any event, there are 2 points of view, and it all comes down to the issue of free speech. So my question presents itself, no matter how you feel about it, and I can tell you, I and many of you have served, and we share a certain view of our flag and our Constitution by virtue of our service. So we're all entitled to our prejudices and our bias. But the question is, intellectually, is what I prize about this group. Intellectually, how do you come out here on the bottom of this slide when we finish talking about it? And that's what I want to pursue for the next 2 or 3 minutes. By taking you through what the Supreme Court of the United States has said. There are 5 cases in total in the modern era which have discussed the issue of respect for the national anthem, flag burning, and the like. I am going to give you 3 citations of the more important cases. And then when I finish, I'm going to ask you the question again. In Texas versus Johnson, a federal law had banned the desecration of the United States flag. Naturally, you can tell a kid he can't do that. What's the kid going to do? So some kids burned the flag. They were convicted, and the Supreme Court reversed, saying, oh no, this is a violation of amendment of the First Amendment. Now, we had an issue actually where I live in my community, in which, like most gated communities, there's an American flag at the entrance. An American flag was put in belatedly in our community, and I was at a couple of meetings in which the issue was raised as to whether or not the flag should be put up or not. And some people felt it was perfect, others felt as though it destroyed the symmetry of the gatehouse and the landscaping, the architecture. And I remember that there was one comment that was made by someone who had served under difficult circumstances. And it was, I had people brought home with me in that flag. But as I thought about it, the flag represented to me the right for you to criticize it and for you to disagree with it. That's why this country is different than any other country anywhere. Well, ma'am, although I disagree with you, and I hope you will not be listened to in this vote, I respect your choice. There's a picture of that young man. Looks like everybody's grandson, doesn't he?
Not mine.
Remember when it
Now, this is Justice Scalia, who gave a CNN interview after he sided with the majority in the Johnson case. And for those of you who are unable to read it, if it were up to me, I would put in jail every sandal-wearing, scruffy, bearded weirdo who burns the American flag. But I am not king.
Amen. Thank God.
Does that tell you? Does that tell you something? 2015, we got another case, Dariano case. A lower court had allowed the school to ban the wearing of United States flag T-shirts. The American Civil Liberties Union took the matter up to the Supreme Court of the United States. By the way, your group supported that, and you lost. But do you know why you lost? You lost because these students had gotten together in Southern California to contest Cinco de Mayo Day and to bring the American flag in the faces of young Mexican children. And there was violence every time they did this, every year. And because schools are horrendous and local, take the place of the parents and local police, in order to protect the well-being of the children, they banned the American flag being worn on the T-shirts of these kids who were looking for trouble to hurt others. And the Supreme Court denied certiorari. An unexpected result? Maybe not. Unexpected comment by Justice Scalia? Maybe not. It is intellect over emotion. It is reason over emotion that governs in these most trying times, if things work as they should. And finally, is there anybody?
What you're just saying here, reason over emotion. So with what's going on now with this thing with the president and the flag and that, what category does that come in?
Well, I'm about to ask you that question. If you can wait just 1 second, I'm going to ask you that question right back. See, I don't answer questions, I ask them. The purpose of this, of my lectures, is not to have you go home and tell all of your friends what you should think. If I leave here and you're confused, that's great. Because there's nothing wrong with that. It means it'll stimulate your thought process some more. Everybody remember Snyder versus Phelps? Let me show you a picture. You remember that? You remember a young Marine, Snyder, who was killed in action in Vietnam?
Vaguely,
Pardon me?
vague record.
Vaguely? Then remember it clear as day tonight. The Westboro Church, Baptist Church, would parade outside on the sidewalks of military funerals with grieving parents.
Oh, right.
We together now?
Yeah.
And they would scream and have signs that said very horrible things about soldiers, about religious groups, about the United States of America. And one of the things they held up was this flag. Do you know what the upside down American flag means? Distress. Distress. Danger or distress. And I chose this picture because this group, amongst other things, treated the American flag with disdain. So, what did the Supreme Court say in this case? It was the First Amendment right, because they weren't physically hurting anyone. If there was ever a hard case in which the primacy of the First Amendment was to retain its vitality, it was Snyder versus Phelps. Many of us have been involved in a circumstance where people whom we know were brought back in this flag. I can tell you that. But nevertheless, the Constitution guides the U.S. and the Constitution guides us. So, whatever your point of view is, please accept one thing, through and including today, the Supreme Court of the United States values free speech, First Amendment, over any emotional reaction, no matter how understanding. And now you decide what you all want to do. Can't answer your question any better than that, can I?
I can't answer my own.
That's the point. And if you can't answer your own, that's not bad. It means you're going to go home, you're going to think about it, you're going to talk to your children about it, you're going to find that there are disparate views. And then you'll try and explain your view, and somebody may change their minds somewhere, or somebody may not. Okay, back to recipes again. How many of you have heard the word collusion? Is there collusion going on? Of course. Collusion between the Trump administration and the Russian government. Because if there is a concerted effort involving the two groups to implicate or affect the American electoral process or the government scheme, it is a felony. I don't have to get into what it's all about. You'll all hear about it soon enough, if, as, and when. There's a causal nexus which is ascertained. But let me please clear up one thing at the outset. The word collusion has no legal meaning. So forget about the word collusion. Rather, we are talking about the federal crime of conspiracy to violate another federal law. Now, when I was prosecutor a few years ago, when my hair was a little darker, we always would throw in account, anyone else ever prosecuted? Anyone else ever acted? Well, we always threw in account for conspiracy. Because when you're throwing against the wall and you're putting all the possible crimes that be committed, conspiracy usually sticks. Because in order to have conspiracy, you don't have to ever show the crime was committed. You just have to show that 2 or more dopes planned the crime, and in some instances created one overt act in furtherance of the scheme. Now, I never said that people were geniuses, when they do these things, even at the highest levels of government. I mean, to have an email that says, wow, if you can bring me this stuff on Hillary, that would be great. You don't have to really be a genius to get yourself involved. Now, that's an acknowledged and admitted fact, which may or may not turn out to have some importance one of these days. So you need a conspiracy. It's just 2 or more people talking about it and saying, here's how we're going to do it, whatever the crime is. And then possibly committing one overt act. And the overt act doesn't have to be a big deal. It can be a small deal if it requires it. So keep your eye on the word conspiracy. Because conspiracy, which is a violation of 18 United States Code Section 371, conspiracy is planning on doing something. It doesn't have to be calculated planning with diagrams, and it doesn't have to use Watson of IBM. It can be 2 jerks sitting down in a car saying, don't you think it would be a good idea for us to do this stuff? The other guy said, yeah, let's do it.
That's what they sound like.
Do they have to?
That doesn't have to ever come to fruition. You don't have to prove that it comes to fruition. I have one other prosecutor in the room. Anything to add to that?
I've always thought there should be 2 crimes, felony stupid and misdemeanor stupid.
Most of our convictions were not from geniuses, were they? Okay. 2 or more to commit a crime with only a single overt act in some of the crimes. Some you don't even need that in furtherance thereof, all right? Okay. Get ready for the next one now. Am I moving too fast for you? You hanging on all right?
Good,
Okay.
good, good.
It's like cartoons, isn't it? Sure. Yes, sir.
Yes, just a quick question.
Go, please.
You were saying that the Constitution is
How am I doing?
sovereign.
Just one
So,
sentence.
Are you
Oh, I'm
gonna-
doing okay. Yeah.
Are you going to address the primacy of, say, the First versus the Second Amendment? Because you probably know there have been cases where the 2, excuse me, have been in conflict, like the Docks versus Glocks case, where...
Docks versus Glocks.
Exactly.
Well, that was a Florida case.
Well, precise.
Docks versus Glocks was dealt with a statute, a Florida statute of our legislature in its most infinite wisdom. Had said that if you're a physician and a patient comes into you like this, you can't say to that patient, excuse me, sir, is that bulge in your pocket a loaded weapon? You can't say that, right? You're prohibited. And you can't get into that at all. Well, the Circuit Court of Appeals for the 11th Circuit in Atlanta said, are you crazy? And said, it's a free speech issue. And the Docks beat the Glocks
So
to address your particular
does one
problem.
take precedence over the other of the amendments? The first versus the second?
Are there times when certain of the amendments will have more efficacy than others? Yes, of course. And the Supreme Court will painstakingly go and try and explain why one does not apply foursquare while another one applies 100%.
I think what he's asking is, does the First Amendment take precedence over the Second Amendment always, or does the First Amendment more important than the other
Right.
amendments?
I don't. Thank you for making the restatement as clear as you did. I can't tell you that there's any such preeminence given to either one. The Second Amendment, by the way, I'm starting to stray, but the Second Amendment, which was the subject of the Supreme Court's determination in a case called Heller, Heller, and by the way, there's Heller 1, Heller 2, and Heller 3. But the Supreme Court of the United States said, much to the surprise of those who are fans of the National Rifle Association, much to the surprise, You do not need a permit to maintain a loaded gun in your home for self-defense. You don't need lock boxes, you don't need it unloaded, you don't need the key in a separate place. So when the burglar comes in, you can say, excuse me, give me 5 minutes till I find my key. You don't have to do that. But the Supreme Court of the United States has never gone beyond that. So the issues of carrying guns outside, having permits issued for carrying outside, have been the subject of state, county, and local municipal decisions. And they have almost uniformly been sustained. And the Supreme Court of the United States has tiptoed around this issue and never gone back to discuss. By the way, there are a couple of cases that might be pending at the moment, but to this date has never gone beyond that and has never come back and said, okay, now let's address, can you carry an assault rifle down the street with you? They're not there. I hope I made up for that with a little bit of extra discussion. Okay. Does the Emoluments Clause cause pain or grief to President Trump? The Emoluments Clause. You're going to hear a lot about this Emoluments Clause because there is a major case pending now in this very early stage where the plaintiffs are being represented by a coterie of counsel who are quite impressive. That doesn't mean they're right. It just means they're impressive. Lawrence Tribe from Harvard University is one of the major lawyers, along with the dean of the law school at University of California, and I can't remember where, Berkeley, I think, and several other academicians. That doesn't mean they're right. That's the second time I've said that. Please don't jump to any conclusions. Here is Article 1, Section 9, Clause 8, the famous Emoluments Clause. No person holding any office of profit or trust shall, without the consent of the Congress, accept of any present emolument of any kind whatsoever from any king, prince, or foreign state. You know, if you can't get anything and keep it. If a gift is given to the President of the United States from a foreign potentate, that gift is cataloged, put into the Smithsonian, and left in the Smithsonian for public viewing. It's not retained. It's not retained by the President to his own use. Sir?
Who can bring a case?
Fair question. Who can bring a case? If you give me 10 seconds, I'll try and answer that for you. You anticipate the next clip?
No,
You did? You did. All right. Citizens for Responsibility and Ethics in Washington, otherwise known as CREW. You may have seen one of the counsel for CREW, who was ethics attorney back in the Bush administration, who often appears in a couple of the networks giving his opinion, versus Trump. This is the case to keep your eye on. This case was filed in January of this year in the United States District Court in the District of Columbia. There's the case number. So just look up this case, CREW versus Trump, and here's the docket number, and you'll be able to follow this case as it proceeds through the United States District Court. There we are. There's your question. Do the plaintiffs have standing to satisfy threshold controversy requirements? Who can bring the suit? Who are the people? The people who were plaintiffs in the CREW suit included, without limitation, hotels, restaurants that used to have significant business that have lost their business dramatically because all the business is going to
His hotel.
the Trump Hotel.
Yeah.
Okay. So the argument of as to whether or not they have standing, are they truly aggrieved people to be the subject of being plaintiffs, is being argued now. We don't know the answer yet. They keep buttressing the plaintiffs by adding new ones. And I keep following this case as they add more and more plaintiffs to show that real entities and real people are indeed being hurt by the very existence of the hotel, which is owned by the Trump organization.
I read someplace that the attorneys for Trump himself, President Trump, they argue that only Congress can bring that action, and I don't think the courts have ruled quite yet who can bring it.
The motions that are before the court right now include what you just said, along with several other defenses. What I'm trying to keep sharp is not whether or not it will or not be successful, but what is the legal consideration upon which the issue turns. If I can convey that to you, and we're in accord on that, then this lecture is successful, because neither one of us knows what's going to happen. Everything is a function of proof, believability, and persuasion of the court. This one here requires satisfaction, I'll repeat it again, of Article 3 of the Constitution, Section 2, Clause 2, which says, in order for there to be a justiciable controversy over which a court can take jurisdiction, you have to have people who are going to be suffering because of it, people who are suffering harm because of it, and more direct than indirect. And the rest of it's going to be fact-driven. And the issue is called standing. Do you have standing? I hope I've answered your question sufficiently.
Has there ever been a case? There's never been there.
On standing?
On the Amendment Clause.
I'm sorry?
On the clause itself. On the Amendment Clause.
On the emolument, has there been litigation on the emoluments clause? Not in the modern era. We are in uncharted territory, which is why when I was asked to talk about all of these strange and unusual topics, couldn't resist it, because it's exactly the stuff that you do. The most modern case that discusses how much proof is necessary to have standing is Spokio versus Robbins. And a 2016 Supreme Court decision requires, look at this word, concrete injury. Does that set a rather high bar? I think so. So now at least you understand that as of May of 2016, concrete injury has to be suffered by anyone who wants to be
Excuse
trained.
me, what do you mean concrete?
Does that mean
Now,
monetary?
What do I mean by concrete injury?
Yeah.
I mean the Supreme Court said, you should ask, what did the Supreme Court mean by concrete injury?
Yeah, that's what I mean. What does?
I can't, they don't allow me in chambers. Well, know the answer. But it sounds pretty tough.
Yeah.
Sounds pretty hard. Sounds pretty rigid. Bridges are built out of concrete. Buildings are built out of concrete. So it seems they were trying to make a point. How much? We have to wait for the Supreme Court. Yes, ma'am.
Is it only monetary?
No.
Or if you could prove that somebody should have been allowed into the United States and died in the camps in Lebanon.
Standing does not have to be monetary at all. No. As long as it's concrete, whatever that means. Whatever concrete means.
Should we know what Spokio versus Robbins was about?
Don't have time to discuss it with you.
Maybe we make it more relevant.
Don't have time to discuss it with you. Remember, I'm on a fast track here. We're on roller skates here tonight. What about conflicts of interest? Let's try that one on. The president have a conflict of interest? If he doesn't have an emoluments violation because we don't know what concrete means, how about just conflict of interest? My God! Say so. Well, let's examine that. Let's take this straw man and deal with it and then cast the straw man aside. Because if you're going to argue about things, be sure you're arguing about things that have substance, that have staying power. You will be pleased and gratified to know that immunity exists by virtue of federal statute, 18 United States Code, Section 202, which was the subject of a magnificent passage in 1989, which immunizes the President, Vice President, Congress, and the judiciary. It doesn't immunize you. Why should you have immunity? They're special folks, right? You don't like that? What can I tell you? All right, so much for the immunity. They've had immunity from conflicts of interest for a long time. However, may I ask you to keep your eye on one thing that has not been discussed very much at all. You may be hearing about this one of these days when diligent people begin to figure it out and think in terms of further litigation. Because otherwise, it's pretty tough to find president of conflict of interest. Haven't you heard President Trump say, I can't be found violating conflict of interest? Well, he was absolutely right. He was positively right, because his lawyers whispered in his ear and said, Mr. President, you don't have to worry about this. Now, whether or not he had to say it or not was a different story. But when he said, I can't be found to have violated conflict of interest, that's not the law. He was right, and those who thought that he was wrong, in turn, they are wrong. Okay, the Stock Act. What is that about? The Stock Act, it bans Congress from profiting on non-public information. You know, Congress is always debating things like health care and drugs and FCC matters, and if you have an inside track knowing what Congress might do in promulgating legislation, and you go to the stock market and you bet on that, so you'll be on the winning side, you can make a lot of money, right? And Congress was doing that with impunity. Impunity. Until the Stock Act. In 2012, the Stock Act stands for, is an acronym for this, for Stop Trading on Congressional Knowledge Act. Stock Act. Pretty slick, huh? It's like my menu for tonight. Just about as slick as that. All right? And that's Public Law 112-105 in 2012.
Can Trump overturn that too in an executive order?
No executive order can ever overturn a law. He can say that he can say he believes it's unconstitutional, and then we have litigation over it, which is what we had in the famous DOMA cases, where the Obama administration, there's a federal law which said if you're a federal employee, and no federal statute or regulation that permits a marriage of other than man and woman can be upheld. That was called Defense of Marriage Act, DOMA. President Obama said, I don't like that. I think it's unconstitutional. So he whispered in the ear of Attorney General Holder, and Attorney General Holder, then when the lawsuit was born saying that DOMA was unconstitutional because it violated the 14th Amendment, amongst other amendments, which finally ended up in Obergefell last year, a year and a half ago, where same-sex marriage was now deemed okay in the law of the land. The DOMA, which was its precursor, the United States Congress hired lawyers to fight the Attorney General of the United States, who, at the behest of the President, had declined to support the federal law called DOMA. So that's about as close as you can get to an executive order overturning. That isn't what happened. What happened was he whispered to the Attorney General. And the Attorney General decided not to represent the United States of America. Can that happen? Yeah, it happens. Not often, but it happens. Am I okay to go on? No. So we have the Stock Act. No inside information. What about the executive branch? We know Congress can't do it anymore, supposedly. But what about the executive branch? Well, the United States Office of Government Ethics, OGE, its director just resigned about 4 or 5 months before he knew he was going to be fired.
Right.
This is the same guy who had a lengthy exchange of emails and discussions with President Trump, quite acerbic, by the way. Very difficult exchanges in which he was highly critical of the President's conduct. The Office of Government Ethics, which was promulgated to prevent conflicts of interest, of course, issued an opinion of December 12th of last year to the Senate that the President-elect Trump would violate the Stock Act by retaining control of his businesses. Now, that was an opinion by the OGE to the United States Senate, that august body. It's a formal opinion by the agency of the government charged with the responsibility of assuring ethical conduct to the Senate of the United States, saying, watch out! You can't let this happen. The opinion is very vigorous. Well, let's talk about the OGE. The OGE was created by federal law back in 1987. The president nominates, the Senate confirms, a 5-year term avoids overlapping presidential elections, independent agency, all the things you expect that it should be. What's its genesis? You better behave ethically in the government. It arose out of that, out of Nixon. However, the statute does not provide the OGE with any power. It just provides it with the ability to render an opinion to the implicated federal agency saying, this is horrific, don't do this anymore. But if the agency says, calm yourself, Edith, which of course was Archie Bunker's famous line, there's nothing that OGE can do about it, except rent its clothing.
And he resigned, that's right. I remember him getting interviewed.
He just resigned. Now, the Stark Act includes both civil and criminal penalties for participation in what are called insider trading or, and I underscore this, investment contracts. Penalties, big time. Big time. And specifically includes both the President and the Vice President of the United States. Now, this is a doorway that may have an opening if there can be a factual basis for pursuing it. And I anticipate that you may hear of litigation being commenced using the Stark Act if the facts so permit. Anybody remember this scene?
The blank paper?
No, wait a minute. You say these are blank papers. The President of the United States said these are all of the agreements that were drawn in which he gave up control of all of his businesses and put everything in the hands of his kids. And this was the pile. This is the picture. But some people are saying it's blank, other people are saying it's not blank. It has nothing to do with me. But the New York Times took a look at this file. And the New York Times legal staff took a look at this file, and on February 4th of this year said, all the Trump real estate remains in what are called revocable trusts. Revocable trust means that you can take back what you've given and you can control during the meantime. It's a revocable trust. It's not an irrevocable trust, which means it's gone, bye-bye, bye-bye. Ownership and control remain reserved to the president. That's what the New York Times legal folks said, and they put it in a column. Whether it's true or not, I leave that to other people someday in other forums. Now, I was looking for case law. Where has the Supreme Court addressed an issue like this? And you have to go back to 1946 in the case of the Securities Exchange Commission versus Howey, which prohibits the executive branch from profiting from third-person real estate participations, whatever that means. So, there's no Stark Act litigation as yet. I don't know if there ever will be, but I want you to be aware of the fact that there is a potential, if all of the stars align, the legal stars and the factual stars align, for this to be a cause of action that will likely become a cause célèbre a year from now, 6 months from now, 2 years from now. But this is one of those lesser known issues that I want to call your attention. I'm moving along. With a grand jury bill served on a president indicting him or her for obstruction, either that could be a gastrointestinal obstruction, or in this case it could be an obstruction of justice, caused distress to the President of the United States. Now, once again, there are a lot of preoccupations about this subject, and I really want you to take a breath and think about it as I take you quickly through this subject. Will the president have to pay the piper if there has been an obstruction of justice on his part? Or will he be able to take a pill and have it all go away? Plop, plop, fizz, fizz. It's got to be one of the two. We don't know which of the two it's going to be. Here's the statute. Please zero in on the statute. This is where your thinking should begin. Whoever, English majors, don't get mad at me. You may think it should be whomever, but the statute says whoever. Okay? Whoever corruptly, and corruptly means evil intent, animus, the intent to do evil, the intent to commit crimes, the intent to defraud, the intent to do bad things. Whoever corruptly or by threats or force, or by any threatening letter or communication, influences, obstructs, or impedes, or endeavors so to do, the administration of justice will be guilty. Now that's what it means. Whoever puts an or in to obstruct the administration of justice, to get in the way of government officials who are trying to figure out if a crime has been committed, who goes out of his or her way to block the normal processes of government investigators, FBI agents, prosecutors, and the like, or Senate and House committee people, or the like. Whoever gets in the way to prevent determination being made shall be guilty. That's what this is all about. That's what this allegation is all about. Did the Trump administration or any of its principals conspire? I didn't say collude, remember that? About 14 years ago when we were first getting this lecture? It seems like it, doesn't it? Yeah. About 14 years ago, I told you collude means nothing. Did they conspire? Hey, that would be great! Bring her all down. Bring the Russian lawyer down. Now, I don't know what that means yet, but we're going to find out one of these days. Could that be a violation of this crime? And what's the presidential liability for it? For doing anything wrong, not just obstruction of justice. Understand the general parameters now of presidential liability, will you? Now we know what obstruction of justice may not be, as well as what it might be. And the jury's open because we don't know the facts. You see, these matters are fact-driven. And that's what Mr. Mueller is involved in right now. Without leakage, interestingly enough. Whether or not there'll be sufficient facts upon which to move forward, or sufficient facts to say the president should be exonerated, remains to be seen. Please do not jump to any conclusions.
Can I ask you a question on that when you talk
Madam.
about facts? When you say facts,
Excuse me for looking at watch, but I have to be sure. I'm almost at my 7:30 time, so.
the facts,
Do I have an extra few minutes to go? Okay.
the facts have to be somewhere in writing? It cannot
No,
be
the
verbal?
facts don't have to be in writing. They have to be facts that are admissible in evidence under the federal rules that apply. Federal rules of criminal procedure that would apply, or the federal rules of evidence that apply. And a judge allows the facts to be in, and jury people like you are either persuaded or not persuaded by the admissible evidence. It can be smoke signals, it can be oral accusations, it can be writings, it can be tweets. I used to think they were called toots, by the way. So my grandson told me, he said, Papa, you can't talk that way. You got to get with it. It's a tweet. I said, so he was right and I was wrong. Okay, presidential liability generally. Civil liability for torts. Now, please, a tort is not a pastry. A tort is any civil wrong other than a breach of contract. Automobile cases, assault and battery with a civil liability. That's a tort. Any wrong on which you want to claim damages or seek other relief that is not a breach of contract is called a tort. So, civil liability for torts committed by a president before she or he became president. Can you think of one? Oh, Paula. Is there anyone here who doesn't remember Paula Jones? Big time. She collected big time, by the way. You think she went away? She got paid a lot of
Not to
money.
mention Monica Lewinsky. Oh,
Well,
that
I'm
was
not
prior.
mentioning Monica Lewinsky. You might, but I'm keeping this on a higher plane, see? Civil liability for torts prior to the presidency. Clinton lost to Jones, he had to pay up. Civil liability for violation of the Constitution during the term. President Nixon. That's pretty simple. But there's immunity for all other civil wrongs during the presidency, even after the term ends. And that was the case of Nixon versus Fitzgerald. The fact pattern is not important to this lecture, but it simply outlines the parameters of exposure. I want you to understand the outer limits of exposure of the President of the United States. If I can do that, and I disabuse you of some commonly held misadventures, based upon commentators all over the place talking about it, then this lecture is a success. Otherwise, it's not. There is no executive privilege to obstruct criminal process against third parties other than the president. Did the president have anything to do with the statement that issued on the airplane which said the whole business with his son was just a simple misunderstanding and had nothing to do with anything? Why do you think that Mr. Mueller is vitally interested in interviewing people who are on that airplane now to determine, did the president have a hand in it? Did the president draft it? You recall that Sarah...
B. Sanders?
Yeah, well, I didn't want to leave out the hyphenated name. I'm sure most of you may recall the fact that he said he only did what any good father would do. Maybe true, but it may be obstruction of justice. Maybe, maybe not. Anyway, there's no executive privilege to obstruct criminal process against his son or anybody else. Now, let's talk about, now that we've circled the wagons, now let's get back to obstruction of justice. Those are the two antagonists, of course. Is the president potentially criminally liable? Well, let's look at the Constitution first. Silent. Let's look at federal statutes. None. Let's look at court determinations. None. Let's look at indictments that have started process. None. All we have are 3 opinions by Department of Justice and special prosecutors that have dealt with the issue. 1973, Department of Justice Legal Counsel. 1974 and 1998, special prosecutor memos, all of which said, I think, or we think, that under our analysis of the Constitution, it's okay to indict the President of the United States while he's sitting in office. But let's not go there. Let's impeach him instead, because we really don't know the answer, because it's never been determined. So, where are we today on this issue? Let me, as the President says, let me be abundantly clear about that. Let me be clear. I have the faintest idea. We're in uncharted waters. We have never been here before. And we're in uncharted waters. So, one more topic here? All right. I have about 4 more in the well, because people have been sitting here a long time. Except for the pizza lovers and the margarita lovers. Stop drinking those margaritas now. Sanctuary cities. Now this is going to be a big deal. This is going to be a big deal. And this is the one you all have a handout on. Okay? Are sanctuary cities Emma Lazarus's dream? Or are they, give me your felons, multiple convictions, and again, where they're sanctuaries for the bad guys? Pays your money, makes your choice. You decide which of the 2 extremes you think apply. Now, the modern origin for the sanctuary city comes, interestingly enough, from Sheffield, England. And it started in the early 2000s. where there were groups that were offering sanctuary to people who otherwise were undocumented. In the United States, there they are. Sanctuary city just doesn't mean cities, by the way. It's a misnomer. Some are counties, some are states, some are villages. But wherever you have a composition, a geographic composition and a political composition in which succor is being granted to those who are uncredentialed, it may be a sanctuary city. As you can see, there are a lot. There are some of the statistics that might give you some idea as to the scope and the breadth of this movement. Now, what's a crime? When does a crime occur if someone who's on the lam, undocumented, and is in this country illegally, ends up in your hometown? What's a crime? When does the crime get committed? A federal crime get committed. Well, there's the crime. There's the felony. All right? And that's U.S. Code. Any person who, knowing that an alien remains in the United States in violation of law, conceals, harbors, or shields from detection shall be fined or imprisoned.
What
So
year was that?
Pardon?
What year this law?
What year is it? It's been around for decades. Decades. So the fact of the matter is that's 1324, 18 U.S. Code 1324. If you, knowing that someone is in violation of law, conceals, harbor, or shields. Now that's your starting point. Always start with the statute. So if you're going to complain about it, know what the statute says to begin with. It's very helpful to do that. 8 U.S.C. 1324. Keep that statute in mind as I go through the rest of this, will you? What are the mutual duties as between the feds on the one hand and the state government?
Excuse me, thank you.
And the state and local governments that may be allowing undocumented folks to stay in their hometowns. What are the mutual duties? And that's 8 United States Code, section 1373. Would you take a look at the handout that I left for all of you? You all have it handy? Now, as this was printed out, it does not say it's 8 U.S. Code 1373. So if you want to add that in on the top, it's 8 U.S.C. 1373. It got chopped off. They didn't pay the rent in time, so it got chopped off. But it's okay. We managed to make it work. All right? Now, I'm going to go through this in a minute with you, but I just want you to have it handy, because the Attorney General of the United States, on behalf of the President of the United States, has alleged that monies are not going to be given to these local governments that the feds believe are sanctuary cities, because that these local governments are unlawfully harboring, unlawfully concealing, unlawfully shielding these people from detection. And that the duties that are imposed upon the local sanctuary cities, so-called, are covered by 1373. In other words, the standards by which they have to act are governed by 1373, which is in everybody's hands now? Okay, don't let it stray, because we're going to be going back to that in a minute. On January 25th of this year, the President issued an executive order entitled Enhancing Public Safety in the Interior of the United States of America. And there's the executive order. The purpose was to implement the Immigration and Nationality Act, which has been around for a long, long time, which says if you're here illegally, you're a felon. That's what it says, amongst other things. It goes on for pages and pages. And you can be punished. In addition to those who help, those who are shielding under 1324. And the president said, we will end the sanctuary citizens that have resulted in so many deaths. But he went on to say, as did his Attorney General on many occasions, that the law has been violated, and since these sanctuary cities have violated federal law, namely 1373, right here, which are the mutual duties of the parties, the feds on the one hand and the locals on the other hand, that all money is going to these local governments for law enforcement protections or other matters are going to be held up. And until you stop hiding these illegals, you're not going to get any money. That's essentially what the executive order says. There are some exceptions, but not many. Now, Section 9 of the executive order of the president, that issued in January, says policy of executive branch is to ensure that local and state jurisdictions that fail to comply with applicable federal law do not get any money. The Attorney General and the Secretary of Homeland Security shall ensure that jurisdictions that willfully refuse to comply with, oh, look what the executive order says, with 1373. So that means they're pointing to what's in your hand as being a violation of federal law and saying that if they continue to violate 1373, which is their duty, they're not going to get any money. We okay with that? Everybody get that all right? Okay. Keep this close. Are not eligible to receive money. Major sanctuary cities, I don't have to discuss. New York City, Orange County, LA. Chicago is the big time case. You're stealing my clicker time. I'll talk about Chicago in a minute. Jim, when you're getting my way. I hate it when the students are smarter than the teacher. It really annoys me, but it keeps me in my position.
Chicago, Cook County.
Secretary of Homeland Security is given the power to designate and define what's a sanctuary city. One might think Congress would have that right under a federal statute, but Miami retreated, New York, Chicago, San Francisco, Boston, other all decided to fight. Why did they become so brave?
Because
Why? I mean, you know, people don't usually say to the federal government, well, with you, we think you're absolutely wrong and we're standing up on principle. Well, they're usually considering the interest to go along with the principle. And the question is, do the local jurisdictions believe that they violated 1373? Because that's at the heart of the president's executive order. Now, there's some lawsuits that have been started already in different cities. But before I get into the lawsuits, understand what the sanctuary cities are saying about themselves. They're saying, we're not impeding, we're not violating any law, we're not violating the federal statute, we're not doing anything that would have us committing a felony. We're not enforcing immigration, detainers, that means when immigration tells a local jurisdiction that's a sanctuary city, you got a guy in jail for being drunk overnight, he's an illegal immigrant, we want him, hold him, don't let him go tomorrow. That's called a detainer. To restrain illegal aliens after completing a jail term for local authorities. The local police do not ask for status. Don't ask, don't tell. Where have I heard that phrase before? Nor arrest illegal aliens per se. That's a federal crime, not a state crime. If I find out you're an illegal alien, what jurisdiction do I have if I'm a beat cop in Palm Beach Gardens or Boca Raton or West Palm to arrest or to notify the feds of known illegal status? But on the other hand, they're not protecting, harboring, or secreting. They're just, we don't ask, we don't know, we're not doing anything to get in your way. It's a federal crime. You do whatever you think you have to do. Just don't ask us to be your instruments to do it for you. So, two queries now. Under the piece of paper in your hand, must states or other sanctuary city designations assist the federal government in enforcing federal law when requested or risk losing the money. And now we come to reviewing the handout. Okay, let's take a look at A. Everybody have it in their hands? Anybody want to buy one? I'm selling discs. Oh, that's a difference.
How about hats? So you have
Like this on the front side.
Coming.
There's A, B, and C. If you don't see A, B, and C, you don't have the right thing. In general, B is additional authority, C is obligation to respond. We all okay? Okay, let's look at A. Notwithstanding any other provisions of blah, 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 right? No official may prohibit or in any way restrict any government entity or official from sending to or receiving the Fed's information. Does that mandate that information must be sent? No. It just says if they want to send it, you can't prohibit it. It's the opposite. So, we're not talking about A being violated by the sanctuary cities. Well, it must be B. So let's take a look at B. Notwithstanding other provisions, blah, 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 nobody can stop sending such information and requesting or receiving it from immigration naturalization. No. Maintaining such information. No. The Attorney General is saying that simply because they're allowing them to stay in their town without doing anything, they're violating Section 1373 and thus are not entitled to any money. And the last one, of course, is exchanging such information. Well, that's gratuitous too. That's voluntary too. So it ain't A and it ain't B. Heaven's sake, it has to be C. If it isn't C, then what the Attorney General of the United States has said doesn't hold legal or constitutional water. There's no violation of a federal crime. So please, let's go into C to put our minds at ease. C, the Immigration and Naturalization Service shall respond to an inquiry by any federal, state, or local government seeking to verify or ascertain the citizenship or immigration status of any individual and can provide requested verification. Where is it mandated that the states or the local sanctuaries have an affirmative legal duty to turn these people in? So, with that little discourse in mind, you begin to understand why the sanctuary city folks are puffing a little bit. And the sanctuary city folks are saying, we haven't committed any federal crimes. Are you a silly goose? It's not us. Did it violate the Constitution, did the order? Well, let's understand, before you can impose all of these things upon the state, even if there's no federal crime violation, you can impose the will of an executive order upon a state. Remember a couple of basics. States' rights. The 10th Amendment to the Constitution of the United States, 1791. The power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states. You can't force the states to do things that they don't have any statutory obligation to do or constitutionally are imposed upon. Now, James Madison, again, my hero, in Federalist Papers 45, said, the powers of the federal government of the Constitution are few and defined, with all remaining power relegated to the several states and the people. What part of that sentence did you not understand? Multiple Supreme Court decisions, which I do not have time to discuss with you, have all circumscribed federal government intrusions where they didn't belong. Issues? Does the executive order permitting a government agency to define the sanctuary city require Congress to amend or enact a statute as opposed to an executive order? Can an executive order usurp the judiciary's right to decide if a statute willfully violates federal law? Can you have an agent functionary of the executive branch deciding if a criminal violation has occurred? Last time I looked, you have to go to a courthouse to do that. Can the executive order lawfully impose civil fines and criminal penalties where existing federal law only says the illegal aliens are to be deported? Does Congress have to do that? Can the executive order lawfully commandeer, and the term is dragoon. That term has historical significance, which I don't have time to get into, but it's been used for years and years. Commandeer, it has a great sound to it. Commandeer and dragoon, state law enforcement, where the states don't want to. So, we now have one case where the United States District Court has issued a temporary interlocutory opinion and a preliminary injunction addressing all of these issues. We now have the very first case, and that case is entitled Chicago, Chicago, I'll show you around. Here's your case. Keep your eye on this case, sports fans. This is the very first case in which, after a full evidentiary hearing, a court has issued a preliminary injunction under something called Federal Rule of Civil Procedure, Rule 65, that says, you know, unless we stop the feds from doing this stuff, there will be irreparable damage caused to the states or the sanctuary cities because they can't get money they desperately need. Is that saying goodbye to me? 5 minutes. How about just a shake? Okay. There could be irreparable harm. We think there's more likelihood than not that they'll win the ultimate case. This has the government going, oy, 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 or words to that effect. See?
Excuse me, you mean Chicago will win the case? Okay.
Chicago received a preliminary injunction enjoining the Attorney General of the United States, the President of the United States, and all others from enforcing the threatened action to take away money from Chicago if they don't begin to turn over people who are hiding in the cellars in Chicago. Okay?
And Rahm Emanuel said,
We don't want to talk about what Rahm, no, he uses intemperate language. We're not going to do that today, are we? Okay, there's the case. Look, in addition to all the alleged constitutional violations, the city has alleged full compliance with 1373. And the city of Chicago argued before the court just what we argued today amongst ourselves in this collegial group. Where does 1373, where does it begin to say that there's any duty in the part of these jurisdictions as long as they're not harboring, secreting, or interfering with the feds? As long as it's just being benign. Where does it say that that's a federal crime? So, the threat is to pull the money, and the standing to bring suit, that goes to the issue that you raised, sir, quite properly earlier tonight. You have to, remember, show concrete harm. How about Chicago being able to say, we're going to lose a ton of money? If Congress allocated the money to us, who in the name of heaven in the executive branch has the right to take away that money that Congress has given to us? Congress is the only one that has the right to take it away. The president is not empowered to do that, particularly since we haven't violated the law. The first federal trial court under this Federal Rule of Civil Procedure has just issued. Now, obviously it's going to be appealed, but this is the beginning. And you remember Winston Churchill, this is not the end, this is not the beginning of the end, this may just be the end of the beginning. Okay. What is the view of this executive order as I bring this to a merciful close before you physically take me away? What's the view of the executive order by the vast majority of constitutional legal scholars? Thank you for the privilege of your company, everybody.
Background to do with all these issues that are on the front page of the paper every day. Thank you for coming. Thank you.